And this one, of course, we have to insist that it comes with a bit of a warning, as this topic is not appropriate for children and may upset some sensitive viewers. So this is just a warning up front. Over the past few years, there have been reports in South Africa of women being wrongfully sterilised. Various explanations have been given for this, most of which are discriminatory in nature, as these wrongful procedures tend to be performed on women living with certain chronic diseases of a certain colour and of a specific background. Our next guest says that it is interesting to note that even though there are laws dealing particularly with the issue of sterilisation in South Africa, our courts are seldom faced with wrongful sterilisation cases. This presents certain issues when lawyers are faced with potential cases, as their evaluation and assessment of the merits of the matter are hampered by lack of case law in this regard. Right, let's discuss this. We are joined by Mthokozisi Mapumulo, who is both an associate and litigation attorney at Adams & Adam. Great to have you. Thank you so much for being with us on the program.
It's only a pleasure to be with you this morning.
Last year, we reported on incidents of HIV-positive women who were forcibly sterilised. What does the Constitution actually say regarding the matter of unlawful sterilisation?
Such cases speak to the founding values of the Constitution, such as non-sexism, Ubuntu, human dignity, achievement of equality, and the advancement of human rights and freedoms. It also speaks to Section 12 of the Constitution, being security and safety over, body integrity and all those, concomitant things. So it speaks to the express provisions of the Constitution and also the founding values of the Constitution. It also speaks to the legislation, being Sterilisation Act.
So, I mean, let's have a look at the actual doctors who perform this kind of surgery. I mean, what happens to them? I mean, what are the actual responsibilities that they should face, purely because they're not getting the patient's consent, even if this is what they call a life-saving operation? Surely you still need to get a patient's consent to do this.
Yes, yeah. So the Act, being Sterilisation Act, provides requirements for the lawful sterilisation, and that says to, the person to whom the procedure is conducted needs to be 18 years or above. They need to be capable of consenting, and that will be an exercise altogether to determine if that specific individual is capable of consenting. And there has to be proper explanation of the consequences of such procedures, reversible and irreversible effects. There has to be a thorough advice to the client, and also they need to be informed of the facts that as much as they may have consented, but they do have the right to withdraw their consent before the procedure is conducted.
Yeah.
So those kind of explanations need to be made.
And that is quite interesting. What you touched on there is that you are saying that anybody over the age of 18, you obviously have to give consent, etc., etc., very much so what you've just said. However, we've seen so many instances where parents or guardians of young girls below the age of 18 have just ordered that this surgery gets done. And I mean, that again is a rights violation.
Yes, definitely, because in the case of a minor being someone who's below the age of 18, it can be only performed under very limited, strict conditions, and that would be the case where there is a greater threat. It is performed so as to push away a greater threat to the person's health or to prevent death. So it's not something that can just be performed with the parents or the guardians' consent. And there are obviously legal penalties to the perpetrators, being people performing these procedures unlawfully.
Is there any precedent anywhere in the world that allows a parent to have a teenager sterilised?
There are where obviously, you know, the lawful in the case where, as I've already indicated, in instances where there is a greater threat to life, and it is in that case quite necessary to perform the procedure. But there are also very few cases where these were unlawful, and there's been penalties. But in the South African context, interestingly, we do not have so many cases that have actually gone to court of this nature of unlawful sterilisation. So that's a very interesting point as well.
Yeah, that is. It certainly is. Just a question. I can see that our signal's not looking too good, but at least we still have you and we can hear you clearly. That's the main thing. Can the victim sue health officials if there is proof of unlawful sterilisation? And how do they actually go about doing something like this?
Yes, they definitely can sue under the common law. They can sue for damages, so that is your monetary compensation. And we have common law heads of damages, such as for the victim to recover any past medical expenses that they may have incurred in connection with treatment and observations, examinations related to the procedure, and future medical expenses to cater for future medical intervention. There will also be, if there is a loss of earnings, for example, or the loss of income for the future, and if there has been any in the past, there will also be a general damages claim, which covers the suffering, the pain that the victim has undergone, and there's also a good room to argue for constitutional damages.
Yeah, it's. As you say, there is room to do this and they are well within their rights to do this. However, even as I said in the introduction, and I think you've alluded to it as well, there just aren't enough cases that are actually brought forward and tested in our courts of law. Why do you think this is the case?
I think it's a combination of factors. Firstly, we need to consider the possibility of people not knowing the legal avenues that they can explore. We also need to consider the fact that with such cases, victims will ordinarily have to inject a lot of money in terms of running the whole litigation process. So the claiming process in such cases would be costly, because you've got to involve your experts in the medical field, in addition to the lawyers. So that also is a discouraging factor, I think. And also, we need to consider the fact that people just sometimes, in these cases, you have to try to conceive, for example, and if you do not try to conceive, you wouldn't know. Chances are you wouldn't know you were unlawfully sterilised in the first place. Yeah. So it is a combination of factors.
Very and exceptionally complicated, and as you say, so costly. Just finally and very quickly, we've only been talking about women, but I need to ask you: are there any cases out there of male forced sterilisation?
Not that I'm aware of in the South African context, but there may be in the other jurisdictions, because the Act, being the Sterilisation Act in the South African context, regulates sterilization both for men and women. So there's not discrimination to that in that regard. Yeah. So in theory there would be, but I'm not aware of any that involves males.
Indeed, yeah. I needed to ask that, however, just in case that's something of an issue. All right. Mtoko Zisi, thank you so much for talking to us here on the program. He, of course, is as an associate and litigation attorney at Adams & Adam, talking to us about unlawful sterilisation and one's rights if one has undergone this. Let's quickly take a break.